Tony, are you ready to get started?
Yes, Judge.
Okay. Let's go on the record on cause number DC 215658 On Deck Capital versus IPEC Network et al. Counsel, make your appearances.
Vince Handler for plaintiff.
Susan McClellan for IPEC.
All right, let's go ahead and proceed.
Thank you, Your Honor. IPEC has filed a motion to dismiss as sanctions due to the fact that initial disclosures were due on this case July 7th of 2021. The defendant complied with the initial disclosure requirements of the rule. We have not heard any sort of feedback from the plaintiff until today. Appears at this hearing, and we've had no disclosures. This case is set for trial September 6th of 2022, and we need to do something to either decide if there's going to be a prosecution of this case and compliance with the rules of discovery or not. So we're asking that the court dismiss this case on the basis of the failure to comply with the initial disclosure requirements, or just on the basis of failure to prosecute it. Thank you.
Mr. Handler?
Thank you, Your Honor. I'm appearance counsel in this case, so I don't have the details regarding plaintiff law firm's failure to provide disclosures. However, I can say that plaintiff is willing to provide the disclosures specified by the rules. Plaintiff concedes that the disclosures are late and would have no objection to an order to compel. Plaintiff does object to any sanctions. Contrary to defendant's motion, this is not a situation of discovery abuse. Plaintiff is simply late and is not resisting the disclosures at all. And there are standards for imposing sanctions. Sanctions must be just. The punishment must fit the crime. And it really, as the court knows, it's a two-part test. The sanction must be directly related to the offensive conduct.
Mr. Handler, the concern I have right now is that, and no offense to you, but the attorney that was responsible for this is the one who should be arguing this, especially since this is on Zoom. So I don't understand why you don't know why they didn't respond to it, and that concerns me.
Well, from my understanding, when I was asked to be appearance counsel, in my opinion, probably an automated request that was sent to me indicated that this hearing was for trial. Obviously, that's not the case. When I was preparing for the appearance today, I realized that this was a discovery issue. So I think it boils down to somebody at the law firm just is not paying attention to the documents being filed in this case by defense counsel. So I suppose my report back to the law firm today after today's hearing, alerting them that they have dropped the ball on the disclosures should rectify the issue, which means a simple order from the court to compel will promote full compliance and is probably the appropriate remedy here.
Who is the attorney, Ms. McClellan, for the other side?
It's hard to tell exactly, but Tyler Lambsman is the attorney that I understand is the last attorney who has undertaken this fall matter. There was another one,
Who's lead counsel, I guess?
Jacobitz, I believe, was the one that we had communicated with initially on this case. And I believe
person named Peterson, according to my records, Peterson is lead counsel.
That's not one that I believe we've personally talked to on the phone, but that could have been the attorney of record that actually filed a lawsuit. It's been very difficult and confusing, honestly.
I don't blame you. This is not.
You're correct, Your Honor. Eric Peterson signed the original pleadings. He's never had any direct communication with us until last week. We finally got his attention to try to get his agreement to set this hearing for this particular date. He asked that we send him copies of the motions that we'd filed because he couldn't find them, so we did. Jacob Feigelman is the other counsel that we had dealt with early on in this case. And then Tyler Lansdom, who's also on the pleadings. was the one that we spoke with initially about the delay in getting the initial disclosures to us. So those are the attorneys that we have dealt with.
Okay, what I'm going to do, I think what your request at this point, Ms. McClellan, is a little extreme. I will grant the motion to compel. I will grant sanctions in the amount of $1,000 against Mr. Peterson personally for not appearing here and not giving Mr. Handler instructions and for not answering discovery. He's lead counsel. If you could include all of that in the order, that it's based on his failure to respond to disclosures, failure to appear for the hearing, and failure to give adequate instructions to appearance counsel, and that it's $1,000 against him personally, not against the firm, not against the defendant. It's against him personally.
Yes, Your Honor, I'll make sure that I comply with that immediately.
So when you do that, also at the beginning of the order, if you could say that this hearing was heard on March 18, 2022, and if you could share that with Mr. Peterson, the order with Mr. Peterson and Mr. Handler. And do you have Mr. Handler's contact information?
No, I do not, Your Honor. I'd appreciate getting that at this moment.
Mr. Handler, what's your email address?
It would be Vince, VINCE, at handlerlawfirm.com.
Okay,
So just share that with Ms. Ms. McClellan.
May I confirm the spelling? Handler is HANDLER?
That's correct.
Okay, thank you. I'll get that right to you.
All right, so email both, and please email Mr. Peterson as well, and then share. And then once you have, they'll have 3 hours to respond. Just let them know in the email they have 3 hours to respond, and then go ahead and submit the order to me as soon as possible.
Yes, sir. I'll be taking
Okay,
care of right away.
Email my court coordinator Rhonda as well as e-file.
I do have Rhonda's email. Thank you.
All right, thank you guys. You guys be safe.